see what we can do there. Perhaps, Rebecca, if you just want to talk about the results of the poll. So we had around equal numbers of people experiencing some change either a while ago or quite recently, or they're currently working through change. And also around a third of people who responded to the poll have experienced a lot of change or feel they're in a constant state of change.
All right, thanks, folks. I can see that here. So it's it is quite interesting that the number of employees who are either in a state of constant change or are currently working through that major workplace change, like I said, it is a very topical issue for organisations who are funding dependent, and yeah, it definitely can have a big impact on your workplace. So I imagine that for a number of you that, you know, it could be quite disruptive to the work, to even to your clients. There can be some impact on client delivery of service. So it is a very significant issue.
So I'm just bringing up the PowerPoints for you, Rebecca. So once that's loaded, I'll get you to just let me know when you want to change the PowerPoints through. Thanks for your patience, everyone. I'll be happy to get those up on the screen now.
All right, and we're up to slide 5. Thank you, Carl.
Okay, no worries.
All right, so sorry, before we cut out, I'm not sure exactly where it cut out, but we were talking about, you know, when an employer must consult, and, you know, the very first one is during a restructure. So a restructure can be when an employer is looking at changing an employee's PDs or changing the reporting lines in the structure, introducing new technology, which might have a significant impact on the employee's role. So it might be a way of actually entering data or something. There might be a more streamlined process as a result of the new technology, and that's going to have a significant impact on your employees. So it's really important to remember that, you know, wherever there is an introduction of this major workplace change, and that is when an employer is going to have to start engaging in consultation. Again, for making positions redundant, an employer must consult during that process. So whether there's an introduction of new staff coming in, so if the positions are being changed so significantly that your existing employees can no longer perform that work and you're having to make those positions redundant and bring in new staff, you'll have to go through a process of consultation. But additionally, if, you know, positions are being made redundant and some of the work that was performed by those employees is transferring over to existing employees, you have to be mindful of the fact that those existing employees who are going to be picking up the work, they also have to be engaged in that consultation process. Again, so where an employee is making changes to rosters, so you know, a process of consultation has to be engaged in, but that consideration has to also be given to any provisions that you might have around changes to rosters. So some arrangements are in place where there might be 2 weeks notice, or a change to roster can only be by agreement. So it's always important to remember that all of those factors have to be considered. Again, so changes to the working hours, that might just be a change in the spread of hours, you know, that's going to have a significant impact on employees in your workplace. So you need to go through that process with them. If going through as part of the restructure, you're looking at transferring employees to a different location, again, consultation has to be entered into to make sure, you know, there's not going to be those significant impacts on employees that are unmanageable for some employees. If you're looking at relocating them a great distance, that might not be something that they're able to do. Another one is where there's a transfer of business. So if there's a merger between your organisation and another organisation, or, you know, a part of the organisation is going over, there needs to be a thorough consultation process engaged for that. Again, so if there's going to be a significant change to a position description, and employees are going to have to undertake retraining to be able to adopt to those changes, then you need to go through that process and identify to employees what those changes are going to be and the types of training that need to be undertaken. All right, Carly, I'll get you to go on to the next slide. Hello?
Hi, Rebecca. You should be on the next slide now.
Right, thank you. All right, so there is a prescribed process about what it means to consult for the purposes of the legislative obligations. Consultation requirements will, however, be dependent upon the particular circumstances of the change. And it is imperative that the consultation that is undertaken is genuine, and employees genuinely have the opportunity to influence the outcome of any decision. That doesn't mean necessarily that an employee has the right to veto a decision, but certainly they should have the opportunity to participate in that decision-making process. So the information that is required from employers includes information about what steps have been taken to mitigate the adverse effects on employees. This might include information about training opportunities being considered, assistance to find alternate employment, redeploying an employee into a lower level position. So they're all steps that an employer might take to actually mitigate the adverse effects. And part of your conversation with employees needs to be in relation to that. So you might look at, providing employees with, time off work to go and look for an alternate job, or you might say, okay, we can't do this work. You don't have the skills and qualifications for that, but we're willing to put you through a training program to assist with that. So certainly that information needs to be provided as well. So employers are also required to provide details about the number of affected employees. So what that means is all employees who are going to be affected need to be provided with the information, including those who will be remaining with the organisations in the case of a redundancy. And one of the key things is also, the nature of the change. So you have to provide information and in writing to your employees about the actual nature of the change. And so what that actually means, what is it that the organisation is proposing to do? What is the impact that that's going to have on employees? How's that change going to affect everybody? It's really important that there's a significant amount of detail provided in that information, because it makes employees be fully informed about the decision-making process and understanding the rationale behind what's being proposed. It also gives greater opportunity for them to provide feedback on what's being proposed. And quite often what we find is that employees, they're the ones on the ground doing the work. They're the ones who are going to have the knowledge and understanding of the role requirements. So it's really good to engage with them and get that information. Now, sometimes what's really missed in consultation discussions is the information about the timing of the change. And what that actually is around, well, what's going to be the process for implementing the change? So once the decision is finalised, how long will it be from that decision until the change is implemented? Is it going to be rolled in over a number of months? Is it going to take immediate effect? That information is all really important to employees during the consultation phase. Carly, would you change slides again? So to ensure that the consultation obligations are met, employers need to ensure that they engage in consultation early on. So as soon as practicable after making the decision, employers really need to be going out there and meeting with their employees and having discussions around what it is that they're proposing. Giving employees and their representatives a real opportunity to provide their views and opinions on the proposed decision. So really making it available to employees, and where they elect a representative, an opportunity to provide feedback and to demonstrate to those employees how you're going to be taking that feedback on board, and what consideration will be given to that prior to making a final decision. Remaining open to suggestions. So it's really important that employees don't just shut down suggestions made by their employees. There really needs to be some genuine consideration given to those suggestions and feedback, and then giving feedback to your employees about, well, thanks for the suggestions, this will work, for this reason, or perhaps that's not such a great idea and these are all the reasons why it's not going to work for our organisation. Providing comprehensive information to employees about the proposed decision and make sure it is in an accessible format. So, you know, you need to make it so that employees are actually able to access it and understand what it is that you're proposing to do. Responding to any requests for information from employees. So quite often what we find is that employees will be going back with questions, and those questions aren't answered within the consultation phase, so people don't feel as though they've genuinely been listened to or provided the relevant information during the consultation process. There's no benefit in giving the employees the information after consultation has been finalised. It has to be done during that period. Reviewing any suggestions or review any suggestions or opinions made by employees or their representatives. So it's really important, again, that you actually go through, review all the suggestions that come back. You know, sometimes we recommend that employers will set a specific email address where employees can be sending through their feedback, or having a dedicated person where all that feedback's going, so it can all be collated and genuinely considered as part of the process. And then when you do make a final decision, it's really important that you're actually explaining any changes that you've made to the proposal, or if you haven't made any changes, why you aren't making those changes. So again, it's really about engaging with employees and making sure they're fully aware and across the decision-making process and how their feedback has been considered and whether that feedback has had any influence over the decision. So it's really important to consider your consultation obligations, because a failure to meet these obligations can result in a range of potential adverse consequences for employees, including industrial unrest. There can be substantial costs or significant delays for employers. So, you know, when we talk about industrial unrest, you know, there is the ability for employees to dispute a consultation phase. There is that provision within the award to notify that an employee is in dispute, and that can cause significant delay. And there can also be significant costs if it's found that an employer has breached their consultation obligations. And I do further on touch on a couple of cases where it was found that the employers had failed to properly consult. So it is, you know, it is a really important issue, and it's really, you know, we can't stress anymore how significant the impact can be on your employees, and how without consultation, the process can just really come undone. If you can just go to the next slide. All right, so yeah, you know, earlier on I mentioned about the termination of employment, so the notice requirements for that are contained within the NES. So Section 117 of the Fair Work Act actually sets out what your requirements are for a notice of termination for employees. So if your restructure or your major workplace change is going to result in the termination of employees by way of redundancy or otherwise, then it's really important that you comply with the termination of employment requirements. So it's a very easy to understand provision, and it sets out, based on the use of service, how much notice is actually required for employees. If we just move on to the next slide. So again, another important provision contained within the NES, which employers need to consider, is the redundancy pay provision. So again, if your organisation is going through a restructure, and as a result of that restructure, employees are going to be made redundant, then you do need to provide them compensation in way of redundancy pay. So in Section 121 of the Act actually sets out where exclusion. So for employees who've been there for less than 12 months, they're not entitled to redundancy pay, but also for employers of small businesses, the redundancy provisions do not apply. I'll just move on to the next slide. All right, so yeah, like I said at the start of this session, predominantly it will be the SHADS award that will be providing the terms and conditions of employment for your employees. However, there are some organisations that do have enterprise agreements. Now, all enterprise agreements must contain a consultation clause, and Section 205 of the Fair Work Act actually sets out what the requirements are. So any consultation clause provided for in an enterprise agreement must require the employer or employers to consult with employees to whom the agreement applies about major workplace change that is likely to have a significant effect on the employee, or a change to the regular roster or ordinary hours of work. The consultation clause must also allow for the representation of those employees for the purposes of that consultation. So if an employee wants to have somebody represent them during the process, an employer must recognise that and acknowledge the representative and provide information to that representative. If on the off chance that the enterprise agreement does not include a consultation term, or the term does not comply with the provisions of the Fair Work Act, then the model consultation term, which is provided for in the Fair Work Regulations, is taken to be a term of that agreement. So generally what we're finding at the moment is we're actually utilising the model consultation clause in most enterprise agreements, just because it does seem to capture what's required in those terms, and there's a lot of precedent around what consultation actually means. So we're finding that it is, it's a pretty good clause to actually include in any enterprise agreements that you might have. All right, if we can just go on to the next slide. Right, so the Fair Work Ombudsman also provides a best practice guide for employers on consultation and cooperation in the workplace, and I do recommend that you have a look at it, because they do have some useful information in there, which I touch on now. So some of the key indicators that the Fair Work Ombudsman have identified as benefits of genuine consultation include improved productivity, informed decision making, attraction and retention, an adaptable workplace, and less industrial disputation. So it's really, there are a number of benefits that are there for both employees and the employer to engage in that genuine consultation. If we just go to the next slide. So these are some of the recommendations by the Fair Work Ombudsman about what can constitute good consultation, and these include consultative committees. So normally a consultative committee would have an equal representation of management and employees, and quite often the union would be involved in that as well. Hosting regular staff meetings, these might be weekly or fortnightly meetings just to keep your staff across all of the issues that are going on. Regular performance review to provide some positive feedback and to help employees identify areas of improvement. Sending out written communications to employees, that might be a regular email that goes out, or there might be a forum on your intranet that can be used. And also seeking employee feedback. So that, again, that can be done in a number of ways. It might be via a survey or through forums on your intranet, but really trying to get that feedback at all levels of the organisation, so not just when going through a major change process. So we just go on to the next slide. So the Ombudsman have broken down the consultation, or what they believe to be a good practice note of consultation, into 3 stages. So the 3 stages are information sharing, consulting, and reviewing and implementation. So stage 1 is about what is being considered. So letting your employees know what it is that's being considered, what the organisation is thinking of doing, and the process for that consideration. So how are you going to be consulting with employees? What steps are going to be put in place to provide feedback to employees? How long will they have to provide that feedback and to consider the actual proposal? And then also providing information to employees about how the final decision is going to be made. And just give me 1 minute, I'll just have a quick drink. All right, so sorry, I am starting to lose my voice a bit, so I do apologise. It's really important that employees know and are aware of, how an organisation is going to get to the final outcome and how they're involved in coming to that final outcome. We just go to the next slide. All right. So the second stage is about communicating business needs and priorities. So using a mixture, again, of team meetings, newsletters, emails, or the intranet site. Seeking the views and opinions from affected employees, either individually or through their representatives. So again, that can be via team or individual meetings, online intranet format, forum, or survey, and encouraging a two-way flow of information. It's also really important to review and improve strategies for communication, flow of ideas and information. Can we just go on to the next slide, Carly? So in stage 3 of the consultation process proposed by the Fair Work Ombudsman, it's important that the employer considers the information and ideas obtained and assesses that against the business requirements, that there's a record kept of any decisions made and that the reasons why those decisions have been made. Communicating that back to employees, so communicating the decision and reasons why back to employees and their representatives, to commence the implementation process, and to also invite feedback on the process to improve the next consultation process. So there's always benefit in trying to improve processes that are undertaken within an organisation. So it's really important that at the end of the consultation process, you seek the feedback of employees to see, well, what could have been done differently? How could we improve on that for employees? You know, if there's another major change in the workplace. All right, we just go to the next slide, and I'm just going to ask Charlie if she can talk to the next 2 slides.
Okay, so we should be on the slide that's headed representation. So obviously employees during these processes are entitled to representation, and the employer must recognise the representative and provide information if requested. So if we can go to the next slide. Okay, so the union role, which in the case of, I believe all the participants here would be the services union, is to facilitate consultative process between the employer and the members, to seek feedback from the members in relation to what's being proposed and what their thoughts are, or any other suggestions that they might have about what would work for the organisation, advising members about their rights, getting involved in dispute resolution, and negotiating the implementation of the agreed outcome. So if we can go to the next slide.
All right, so there are quite a number of cases that relate to consultation in the workplace, and two fairly significant cases are the CEPU and Allied Services Union of Australia with QR. So in that decision, Federal Justice John Logan ruled on the 11th of June 2010 that QR failed to consult with its 15,000 employees about future employment arrangements arising from the upcoming sale of QR's haulage network and the subsequent restructure of the government-owned company. Employees did not have an opportunity to engage about how the privatisation would occur, what parts of the business would be privatised, and what employees would be going over to the new entity. In this case, the employer was fined $660,000, which was reduced to $384,000 on appeal, because the employer had dictated what the proposal was and had failed to consult with employees. Whilst QR had provided a significant amount of information to employees about the proposed change, they did not bring employees into the decision-making loop. And this is a fundamental requirement of consultation. So what had happened in that instance is that a decision had been made by the state government to privatise the coal freight of QR and to set up a separate organisation. So, and what they did was they were providing information to employees about what they intended to do, but they weren't seeking any feedback from employees. They weren't engaging with their employees. So there was copious amounts of information, but actually no genuine consultation. And, you know, throughout that case and throughout the process, they were adamant that they were meeting their, you know, consultative obligations. And, you know, it's a really significant decision in the fact that the courts have found, well, no, actually they haven't. That providing information is not enough. You actually have to engage with your employees. You actually have to give them an opportunity to be part of that decision-making process. So it is a really significant case. And I do recommend, if you've got some time, to read up on it, because, you know, it really was a catalyst then for a number of employers across the country going out and then reviewing their consultation arrangements. And, you know, from our union's perspective, we really saw a significant shift with employers after this decision about what actually constituted consultation. And it was no longer just about information giving, it was actually about engaging with those employees. So in his decision, Justice Logan decided excluding workers in the face of radical change was a very serious contravention, and he determined that the penalty had actually been deserved in that. So QR were successful on appeal in reducing that penalty down, but it was a very significant, like I said, a very significant decision at the time. So in relation to the Australian Licensed Aircraft Engineers Association and Qantas Airways decision, Qantas was ordered to pay a total of $41,250 in penalties for breaching its consultation obligations and for failing to provide information that was required for consultation. The case arose from Qantas's announcement that it was introducing a maintenance on demand system for its Boeing 737-800 and Airbus A330 fleet. The introduction of the change resulted in fewer checks being performed on these aircraft by licensed aircraft maintenance engineers and led to the positions of 30 employees being made redundant. It was found that Qantas had breached its consultation obligations under the applicable workplace determination by not genuinely consulting with the Australian licensed aircraft engineers in relation to its decision to make the positions of those employees redundant prior to consultation occurring. This was evident from a letter that Qantas actually sent through to the union, advising that the 30 employees would be made redundant prior to even commencing consultation. Qantas had merely wanted to utilise the consultation period or for a process to determine who would volunteer to take the redundancies. In no way was there, any genuine consultation being undertaken. So the penalties that were applied to Qantas in this case were $24,750 for failing to genuinely consult, and $16,500 for failing to provide information required for consultation. So according to the court, the relatively high penalty for failing to consult was justified for a number of reasons, including the need for deterrence and the fact that the breach involved senior management and a deliberate action by a large corporation. So, you can see from just those two decisions alone that consultation is a really significant issue in the workplace, and it's really important that, employers do engage in a proper consultation process. So, that's really the end of what I wanted to go through today. So I'm open now to any questions that people might have. I might defer to Carly to let me know how the questions are going to come through, just that we've had these technical difficulties.
Okay, no problems. Thank you so much, Rebecca and Charlie, for sticking in there and getting that webinar back up and running with our difficulties in the middle there. So apologies again, and thanks to our audience also for hanging in. So there are two ways that you can ask questions. Probably the easiest and most common way is to just type your question into the question box on your GoToWebinar control panel. So you should see a little chat or question function there. So feel free to pop any questions you have for Rebecca into that box, and I'll read them out so that everyone is able to hear. The other way you can ask a question is if you've got a microphone available, you can put your hand up on the GoToWebinar control panel, and we can unmute you and you can ask your question verbally. So what I might do first is read out the question from Jessica that came through during the presentation. So an important one, and something that maybe other centres also may like to know. So if someone is made redundant between 7 and 10 years of service, are they entitled to pro rata long service leave?
So yes, so that would be. So that would be dependent again on if there's an enterprise agreement in place. There might be some pro rata long service leave provisions that need to be considered. But in Queensland, the long service leave provisions are provided for in the Industrial Relations Act. And I haven't got the act here in front of me, but I'm fairly confident that there is pro rata long service leave after 7 years for employees whose employment is terminated for reasons other than misconduct.
Okay, fantastic. So just keep those questions coming through, everyone, and I can read them out for you. Feel free to ask in a general or hypothetical way if you don't feel comfortable sort of speaking to your specific scenario or organisational situation. In the meantime, though, I think, it was really great to hear a bit of an overview of the modern award for our sector, the national employment standards and the legislative provisions that relate to this area of law. And certainly I think these areas, one, maybe not that specific award that we are under, but the general principles around consultation and communication, this stuff has flow-on effects for the clients that you're helping in employment law areas as well. I also thought it was really great to have a bit of an overview of some of the best practice recommendations that centres can consider and implement. So even certainly while they're in a period of change and are needing to do some consultation and communication with staff and management and engaging in that two-way process, but also for the times where there's no change happening. So very good to implement some of those tips and tricks to help keep the flow of communication going within your service. So Rebecca, no questions are coming through, so everyone's sitting on their questions, and perhaps you may get a call later or an email later. But I will encourage everyone to, if you do think of questions later or you want to go back to your management committees or staff and if there's anything they would like to specifically know, I'm sure that Rebecca would be more than happy to help. So you can feel free to send those through to me. Or directly to Rebecca. But for now, oh, sorry, I think a question has come through, Rebecca. So if you're happy to answer that one, I'll read it out for you now. So Jude's just asked, does the state government have an obligation to provide funding to assist organisations to pay redundancy payments if funding for the service is withdrawn? That's a really tricky question. Rebecca, do you have any information or guidance to provide on that?
So I'm not sure that there's actually requirements on the state government to provide the funding where it is made redundant because of a funding cut. So an employer would have an obligation to actually anticipate that as well as part of their ongoing costs and to have some money set aside for that. There is an obligation though if the organisation went into liquidation. There is a federal department who takes some responsibility for that. So where an organisation goes into liquidation, the fair entitlements guarantee would come into effect. So employees would be able to get any money that was owing to them through a redundancy via that instead. But where the organisation is ongoing, I'm not aware of any obligation on the state government to cover the payments for a redundancy.
So I think it's probably best to plan for a rainy day just in case and perhaps set aside some reserves in your service.
So I think a lot of organisations use fixed-term contracts as a way around that as well to meet the funding requirements.
Yep, certainly. So I've got another question that's come through now from Jessica. So would FEG then try to recover those payments from a management committee?
So they would become, so that wouldn't be through FEG, it becomes through the liquidator and they become one of the creditors.
Okay, so if anyone has any last burning questions they would like to ask, now is your chance while we've got Rebecca and Charlie on the line here. But alternatively, we might wrap up very soon. So on behalf of everyone who has listened in today and those who are also viewing the recording or will be viewing the recording later, thank you so much, Rebecca, for sharing some really insightful information with us, and for Charlie stepping in as well. And thanks everyone for listening and tuning in. I think it's certainly an important issue, and while we may sort of be in a bit of a state of not so much pain around funding cuts or restructure, generally across the sector, it's really good to have this knowledge in your back pocket and to perhaps start thinking about setting up some of those best practice recommendations in your centre to prepare for the worst, if that hopefully that doesn't happen, but it's good to be prepared. So I'll be putting these recording up on our website tomorrow, sometime during the day, and I'll send a link out to that recording to everyone who's registered. And we'll also have the PowerPoints up there as well. And I'll send out a survey, as I usually do, for you to fill out to provide your feedback, which would be very helpful for our presenters. So until next time, thank you so much, everyone, and have a good afternoon.